Welcome everyone to this Privacy Rules webinar. My name is Alessandro Di Mattia. I'm Legal and Executive Officer at Privacy Rules. And today I'm joined by two of our members that are Chiara Agostini from the Italian law firm RP Legal and Tax, and Yugo Nagashima from the US-based law firm Frost Brown Todd. I'm really pleased to have the two of them with us today because we are going to work on a comparative discussion related to two very relevant cases happening in Italy and in the US. That is the Clearview AI case from the one side and the HiQ Lab case on the other side. Those two cases were somehow similar because they are both related to data scraping, the usage of images taken from social media or the internet in a more general manner. But there are some differences we would like to delve in a bit more together with our experts. So what we will do will be just giving a brief overview on the two cases and then see which are the main differences and takeaways of the first and the second one. So in order to do that, thanking again our speaker for being with us, I would like to leave the floor first to Chiara in order to have an overview on what is the Clearview AI case about. Thanks a lot for being here.
Thank you, Alessandro, and good morning, everybody, or good afternoon. It depends on where you are. I would like to thank you for this invitation because it's a good opportunity to talk about a very interesting case in Italy, and we have the opportunity to make a comparison between the European framework and the American one. I'm Chiara Agostini from RP Legal and Tax, and I am the TMT partner of our Italian law firm. And I would like to present the Italian case using some slides to make it easier. So I share my screen. Let's talk about the case. First of all, the subject is Clearview AI, and the authority that admitted the sanction is the Italian Data Protection Authority. And the sanction is really high for the European framework because it's 20 million euro. Referring the subject, it refers to the facial recognition service created by collecting and processing into biometric data billions of web facial images through web scraping techniques. But let's talk a bit more about the service to let you understand more the case. Upon client's request to obtain images to a specific person, Clearview system interrogated its database, first matching the requested image with its own database, then extracting the corresponding images, and finally presenting them to the client as the result of the research, offering metadata and associated links. The search inside the service is made in a database that uses over 10 billion facial images collected on the internet, such as social network, or other publicly sources. And these images were captured through web scraping techniques. Such images were transformed in biometric data using hashing for indexing and search purposes. And this metadata could reveal really sensitive information of the data subjects, as you could have information about the racial and ethnic of the people. You can have the religious belief or the title of the photo, and you can acquire information about the nationality and the language. Likely, not all the clients could freely use this the Clearview service, but only certain categories of clients, such as police forces or government agencies. That's the case, and now let's talk about the main violation that were being funded by the Italian Data Protection Authority. Of course, there were several violations that were founded by our regulator, but I would like to talk about the main violations that were founded and were described in this case. The fourth violation refers to the lawfulness, the fairness, and transparency principles. As you may know, according to Article 5 of the GDPR, data subjects must be informed of the processing of their personal data. They need to know, for example, the purpose of the processing, the legal basis, or the storage period. In relation of these principles, Clearview has been condemned by our regulator as the facial recognition service failed to comply with these principles. And this was because data subject had no contact at all with Clearview, were not directly or indirectly informed by Clearview activities, and data subject did not receive any information even by consulting the Clearview website, because no privacy policy was included. The second violation refers to the purpose limitation principle. Under Article 5 of the GDPR, personal data shall be collected for specified, explicit, and legitimate purposes, and not further processed in a manner that is not compatible with those purposes. As stated by the Italian DPA, the public nature of the online images collected by Clearview was not sufficient to assume that the persons concerned could have reasonably expected to be subjected to a further facial recognition system offered by a private company not established in the European Union and whose existence most of the persons concerned were unaware. This other violation is really important and maybe it is the main one, and it refers to the lawfulness of the processing, which is something that must be present in any data processing in the European Union. According to the GDPR, the data processing is lawful only if there is a lawful legal basis, such as the consent of the individuals, legal obligation, the fulfillment, a fulfillment, or a legitimate interest. Having particular regard to the legitimate interest, this legal basis can be used only if there is a correct balance between this interest and the fundamental rights and the freedoms of the data subject. In this case, Clearview did not obtain the consent of the persons involved and tried to base its processing on its legitimate interest. But the Italian regulator established that the Clearview's legitimate interest could not prevail over the rights and the freedoms of the individuals, since the activities carried out by the company implied a particular intrusiveness in the private sphere of the individuals. The last violation I would like to talk about refers to the representative in the European Union. According to the GDPR, under certain circumstances, the GDPR applies also to the processing of personal data carried out by data controllers as American company, not established in the EU. In this case, the American company or the controller shall designate a representative in one of the member states where the data subjects are. The GDPR applied, of course, to Clearview's data processing as it referred to EU data subject 2, to EU facial images 2. But Clearview did not comply with this discipline, nor it designate a representative in the European country. And because of this lack, it was sanctioned. This is the case, and we will, of course, talk after about the main difference between the Italian case and the American one that will be described by Yugo.
Thanks a lot, Chiara, for this brief overview on the Clearview AI case. Will be definitely useful for our next part of the discussion. But of course, let's get to an overview on the HiQ Lab case from the US perspective with Yugo. So Yugo, thanks a lot from your side for being with us today.
Alessandro, thank you so much. So hi, everyone. I'm Yugo Nagashima. I am a member at the US law firm Frost Brown Todd LLC. And I will be talking about the HiQ Labs versus LinkedIn decision from just recently in 2022 from the Ninth Circuit. So the background to the HiQ versus LinkedIn case is essentially this. HiQ Labs is a data analytics company, and it data scrapes information from the profiles, the LinkedIn profiles that are made public on LinkedIn. I think everyone knows who LinkedIn is. LinkedIn is a social media platform that allows users to basically post their resumes and their recent work experiences to increase either their interests in the business or get a new job. And what HiQ did was basically just go on the web pages where they could publicly access it. And at one point, LinkedIn came back and said, can't do that. So HiQ then filed something called a preliminary injunction against LinkedIn, which is essentially asking the court to tell LinkedIn, don't let them stop HiQ Labs accessing the website. So that's the background. So a little bit more in detail, a little bit of it is a repeat. What happened in terms of chronology is you had LinkedIn who sent a cease and desist letter, which is a letter saying, do not do what you are currently doing, to HiQ, saying that HiQ's data scraping basically violates the user agreement, violates the Computer Fraud and Abuse Act, the Digital Millennium Copyright Act, California Penal Code, and common law trespass. Today, we will focus more on the CFAA mentioned here, but that's for later. So HiQ then says, wait, no, that can't be, because we have a right to access public web pages. You made this information public. You just can't take away our rights while everyone else can still continue to see it. So that is a tortious interference with contract. And what they asserted here is that HiQ has a product which basically allows companies to, I should say service, companies which basically allows companies to figure out what kind of skills employees have. So HiQ would go into the website and look at the employees of a contracting company and say, well, they're putting down these certain skills. And HiQ would use their big data technology to figure out what skills are missing and how those missing skills can be bridged. So there was a contract. That's how they got paid. So HiQ said, hey, if we can't access the web page, we can't perform on the contracts with our clients, and that's a tort. That was the argument. So when this went to court, LinkedIn said two things. They said, well, tortious interference with contract, we have a legitimate business purpose to stop you. You shouldn't be data scraping. That's not the right thing to do. Second, and it's mostly based off of the user agreement. And the second, they said, well, as mentioned in the cease and desist letter, the CFAA violation preempts HiQ from its tortious interference with contract claim. Well, the district court said, HiQ, you're right, and granted a preliminary injunction. This goes once up on appeal. This is the intermediate court to the Ninth Circuit, which is in California, and affirms the district court's grant of preliminary injunction. Then LinkedIn, not happy, further files for a writ of certiorari. That's how you get to the Supreme Court. The Supreme Court, US Supreme Court, grants it and says, well, LinkedIn, you're right, let's vacate it and let's remand the case, and the Ninth Circuit can judge it again based on a case called Van Buren, which talks about the CFAA, which I will talk more in detail when we get to that section. So what was the issue on remand? Pretty simple. It was a preliminary injunction case. So it's stopping LinkedIn from basically locking out HiQ. And it's called enjoining in the legal terms. And you basically have certain elements that you have to meet in order to show that an injunction is okay to give out, which is irreparable harm, likelihood of success, which we're going to focus, the interest of the party, and public interest are the four elements. But here we want to focus on the likelihood of success, which basically like on the merits of what HiQ is arguing and what LinkedIn is arguing, who would likely win. And the two we want to focus is the tortious interference with contract and the CFAA. So tortious interference with the contract claim, it really falls both, but there's two arguments that's being made here, which is the LinkedIn's legitimate business purpose defense. And the issue obviously is, does LinkedIn have a legitimate business purpose? LinkedIn argued as well, data scraping is not right. Users have certain expectation of privacy, and that was one of the arguments made. And the Ninth Circuit said that the LinkedIn did not have a legitimate business purpose, noting that LinkedIn's conduct is not within the realm of fair competition. So the court is seeing it from the eyes of competition between two companies, saying, well, it shouldn't be fair for LinkedIn to basically have all this data, and even though the users have made it public, not give access to HiQ. Another reason that the court said is no legitimate business purpose is this. Before sending this cease and desist letter, LinkedIn CEO went on TV and said, hey, we're making a competitor product to HiQ's Skill Mapper product, which is the product that HiQ was using to basically have the contracts with other companies. So the court said, well, are you really doing it for a purpose of protecting users, or are you really doing it so that you can gain an edge in the market? And so LinkedIn, the second part, let's talk about that, the privacy part a little more. LinkedIn asserted private business interest of protecting its members. The court rejected it, saying the user's privacy expectations regarding the information they make public is uncertain at best. So there's not much of a privacy expectation there. So CFAA, this was the second issue, which is even if there's a tortious interference of contracts claim, LinkedIn said, well, if HiQ is violating a criminal act, they're doing a criminal act, there is no claim. That's the defense. And what the CFAA says is whoever intentionally accesses a computer without authorization or exceeds authorized access, thereby obtains information from any protected computer shall be punished. We're just paraphrasing there. The issue here is whether HiQ's access to LinkedIn data is without authorization. The court found that access without authorization suggests that access is generally not available, and so permission is required. What this really means is it's almost like a trespass concept. So if you have a password protection to get into a website, then there's an anti-intrusion mechanism. There, the gates are up. You can't get in. And if you break through that, you violated the law. But let's say it's a public website. The gates are down, so you could just walk right into it. Well, then there was no issue of authorization or a non-authorization. So you haven't really committed a trespass. You haven't committed a crime. So the court found, well, LinkedIn is a public website as long as people make their profiles public, and it's default free access. So LinkedIn then later added a selective denial of access just to HiQ, but that is not a without authorization scheme as the CFAA has contemplated. So why are the decisions so different?
First of all, thanks a lot, Yugo, for your explanation and your overview. Now I think that time is mature, let's say, to move forward with the more practical part of the discussion, that is the one related to, which are the main differences from the Clearview AI case and the HiQ Labs, and maybe which are the main takeaways that we can take from this, and maybe I don't know who of you would like to start. Maybe Chiara, so that we can shift again.
Okay, I start first. In my point of view, the two cases are different because they analyze the web scraping service on two different perspectives. In my point of view, in the Italian case particularly, the protected right was the privacy right of the individuals, whose personal data were being processed. The competent authority was the Italian regulator, and the case was evaluated under the data protection disciplines. On the contrary, in the HiQ Labs case, the American one, the protected interest was the business interest of a private company, LinkedIn, that acted against the HiQ Lab to protect its member data, but above all the investment made in the developing of its platform. The competent authority was not the regulator, but the US 9 Circuit that evaluates the service taking into consideration the Computer Fraud and Abuse Act, which forbids, as Yugo said, the accessing into a protected computer without authorization and not the rights of the data subject. So two different perspectives and two different decisions. In Italy, it's interesting to underline that we have a crime regulated under the Italian Criminal Code that defends the same interest protected under the Computer Fraud and Abuse Act. It is settled case law that this law is violated only if someone breaches the access security measures implemented to protect a computer system. This rule, therefore, would not be applicable to web scraping of public profile data, since these data are accessible to anyone. So in conclusion, maybe if the Clearview case would have been evaluated by a court under this particular discipline, which is meted by the criminal code, maybe the decision, the Italian decision, would be close to the HiQ Lab case. Another key point that I would like to underline is that, in my point of view, these cases represent the different privacy approach between the European Union and the US. While the US privacy regulation focused more on the protecting business interests, the UA regulation focused more on protecting citizens. According to the GDPR, in fact, the US companies must comply with the lawfulness of processing principle. In other words, if companies want to process personal data, they must have a legal basis to process such data. And this even if the data are collected on the internet from publicly accessible sources. And even if a company bases its processing on its legitimate interest, like Clearview did, such legal basis is not valid if is overburdened by the fundamental rights and freedoms of the data subject. On the contrary, in my point of view, if I understand correctly, it is forbidden for US companies to process personal data only if such processing is forbidden by the law. So really different perspective in my point of view.
Definitely, Chiara. Thanks a lot. And there are very different starting point at the very beginning of the two cases from which to consider, and also the type of authority that was taking the decision was completely different. So I would like to hear from Yugo if he's sharing these differences and which are the takeaways from his side.
Right. So I pretty much agree with Chiara. I'm just gonna say it in a way that I guess us US lawyers think about it. The HiQ case is a litigation. It is between two parties, two businesses fighting over whether someone has committed a tort, which was the tortious interference of a contract. The Clearview case is a regulator action. So it's a government regulator action, authority action on a company for something that we would consider in the US more of a consumer protection arena. So, one is judicial, one is, I think, regulatory. The situation is a little different here. Another important aspect of it is, again, when you're litigating a tort case, the issue is more of, did you meet certain elements? And as we discussed, I mentioned, the preliminary injunction standard coming out. the issue there more focused on, whether LinkedIn could basically kick out, right? Essentially kick out HiQ from its publicly available service. While I think in a Clearview AI case, the issue focused more on Clearview, who we would consider, who's a data scraper, who we would consider more like HiQ, right? So it was a different standard where the focus was on the person kicking out, a platform that's kicking out a data scraper versus a regulator who's going after the data scraper and who's saying, hey, you're not following the law. So the situation's a little different. The other big focus, I believe, is the law that we're talking about. And I think Chiara has pointed it out. The focus was a tort law. It wasn't the focus of a privacy law. The US obviously has privacy laws, more incoming, right? With the CCPA/CPRA, the CPA, VCDP, that's the Virginia law, and the Utah law. But the focus here with the Ninth Circuit was a tort and the CFAA, which was the Computer Fraud and Abuse Act, which was specifically, tort and a criminal law. You had to fit in a certain box. And the issue was really focused on without authorization. And it was essentially, it came down to the issue of, is it publicly accessible to everyone, or is it protected by a password, right? So the situation, the concerns were very different. So for what the courts looked at, and we did see some privacy aspect of it in the public interest analysis, right? Or what the business interest, the protection of business interest by LinkedIn for its consumers was whether the data subject made the information public was a key issue. If the data subject themselves said, hey, I'm okay with this information being in the public, then the court said, well, at least under the framework of the tort law and the CFAA, well, that's public access. So that's without access. And that's without a password. So the gates are essentially down. You're free to take it. Clearview AI, on the other hand, the issue was on GDPR, a privacy law, protection of consumers. And I think the focus there was the conduct of the controller processor. That's what I should say. Did the controller processor inform the data subject of what it was doing, the data processing, and explain its basis for doing it? Did they have a legitimate legal, lawful purpose to do it? And what the regulator said is they didn't. So I think we're comparing a little bit of apples and oranges here, but you do see some difference in the way of how the US and Europe is thinking about publicly available data. So for takeaways, I think I'm just going to get there. At least the US courts, in analyzing personal data and whether data can be scraped, they're looking at it more from a lens of, did the data subject, the consumers, users, provide that information voluntarily to the public? And if they did, the expectation of privacy goes down. So maybe it's fair game. That's at least how the Ninth Circuit is thinking about it. And that is something to keep in mind, because I think that is a little bit different from Europe, because even if the information is public, and Chiara can chime in, you still have to have a legitimate purpose under the GDPR to process it, which there's an additional layer of protection.
Perfect, Hugo. Thanks a lot also for your takeaways. And Chiara, anything else that you would like to add in this regard?
No, I basically agree with Hugo. Of course, we have two different mindsets, because in my point of view, if I made public my images on LinkedIn, this is only to have businesses with someone and to show my image for business purposes, not to to have my image inside an American database for security reasons. So I'm terrified about about these penalties and this scope. But of course, it's different mindset. It's a public image, but it's an image that, in my opinion, shall be used according to the terms and conditions of the platform, and so only for business purposes. That's all.
Very clear, very clear, Chiara. Very clear position. If I can also jump in, I think it was very clear. Also, the difference is not just in terms of mindset, but also of cases from the one to the other. But there are also some point of connection or similarity, because it was interesting the fact that Chiara was saying that this case was under a specific authority that is the Garante, that is an authority that works on the privacy side and not on the criminal side. And then there is a criminal law that specifically address different kind of cases that which was not in this case falling behind the case we were seeing. But if we were having the criminal court, the Italian criminal court handling these, maybe the decision would have been closer to what we have seen in the US. So maybe the real issue here is just about the perspective from which you start addressing the main issue. And that was interesting because on the other side, we know that in the US, there is not yet, at least, an authority on the privacy side, at least. So maybe on their side, it may have been handled differently if there was an authority looking at this under just the privacy perspective. So I think that can be an interesting point also as takeaway from both the side. I don't know if there is anything else from you that you would like to add, but from my side, it was a pleasure to have you here today. So Yugo, I don't know if you have anything else that you would like to say?
Yes, on the last point, again, if it was a regulator decision from the privacy perspective, may it be the CCPA or any other new state laws that are coming in play, the situation may have been different. It's hard to tell now. The US privacy law is developing very quickly, and I don't think that we will stay in the same place. It will continue to evolve, and I believe it's going to become closer to Europe. And what we see here today is not how the US will continue to think, and I think it's likely to change as time goes by. So keeping track and being aware of these changes will be very important for companies.
Absolutely. Thanks a lot also for this last note, Yugo. Thanks to you both for being here. We're running out of our time, so I would like to thank you and thank our listener for following us. And I really look forward to have another meeting with you, maybe considering new development of this topic. Thanks a lot for being here and for your clear explanation and also discussion. See you very, very soon again.
Thank you, Alessandro, and thank you, Yugo. Bye. See you.
Thank you.